Right, so I'm going to make a start. Yes, good morning, everyone. Welcome to our SEND webinar, which is to last 30 minutes this morning. The webinar is being recorded. You will be sent a handout at the end of this webinar, and you will also be asked to provide some feedback. So we would appreciate it if you could do that. First of all, let me introduce myself. I'm Kevin Duce. I have been a qualified lawyer and solicitor for 30 years. 20 years of that has been me advising the NHS in numerous areas of law, including SEND. Can I just say, I'm starting to hear some feedback, so I don't know if people are all muted. If you could mute, that will help us with that feedback. I'm presenting this morning with my colleague Jill Weston, and I'll ask Jill just to introduce herself.
Good morning. I'm Jill, as Kevin has already said. I'm a principal associate in the healthcare team at Mills Reeve, and I have been working in this area for roughly 14 years or so. So Kevin and I, between us, are going to cover the various slides that you've got. If there are any questions as we go along, if you could pop those in the Q&A function. If we've got time, we will pick those up at the end of the session. And if we don't have time to deal with the questions effectively in person on the seminar, what we will do is we will respond to those questions in writing. We'll pick them up and circulate our answers to those questions when we send round the presentation materials and the link to the recording of today. So I hope that the next 25 minutes is useful to you, and I'm going to hand back to Kevin now to take you through the overview and start with some of the detail.
Thank you, Jill. Yes. Hopefully you can see the first slide, which is entitled "Send a Quick Overview." Naturally, as we have 30 minutes this morning, we can only cover the tip of the iceberg really in this area. But let's see how far we get. Obviously, as you'll see from the slide, SEND is an abbreviation for Special Educational Needs and Disability. The relevant legislation in this area is the Children and Families Act 2014, which I will refer to as the CFA throughout the presentation. You'll also see that I've made reference to the SEND Code of Practice. The SEND Code of Practice front sheet confirms that it is Special Educational Needs and Disability Code of Practice for 0 to 25 years. Now, the Code of Practice is some 300 pages long. It has a detailed index and comprises 11 chapters. It's an essential reference document for everybody working in this area. In relation to our webinar this morning, you will be particularly interested in chapter 9, I would suggest, which covers EHC needs assessments and plans. Looking at the bottom of the slide, you'll see that I've set out there reference to what SEND is, and it reads that it is healthcare provision or social care provision which educates or trains a child or young person and is treated as special education provision, abbreviated to SEP. Under section 21 of the CFA, something is SEP if it provides education and training to the child or young person in question. Typically, from a healthcare perspective, that will involve such things as occupational therapy, speech and language therapy, and physiotherapy, which services are provided by allied health professionals at provider organisations. If we could move to the next slide, please. You will see there the slide headed duty to secure SEP and healthcare provision in accordance with an ECHP. I've set out there section 42 of the Children and Families Act 2014, which provides as follows, and forgive me for reading out the section in this slide and the next slide, but it's important to have an appreciation of what that section says. So in relation to the first paragraph, subparagraph, it says, this section applies where a local authority maintains an EHC plan for a child or young person. And you will remember that I made reference to the Code of Practice, which identifies a child or young person as in the range from 0 to 25 years. The second subsection reads, the local authority must secure the specific special educational provision for the child or young person. Next, if the plan, and that's the EHC plan, specifies healthcare provision, the responsible body must arrange the specific healthcare provision for the child or young person. Next, subsection 4, the responsible commissioning body in relation to a specified healthcare provision means the body or each body that is under a duty to arrange healthcare provision of that kind in respect of the child or young person. And carrying on the next slide, please. Subsection 5 confirms that subsections 2 and 3, those sections I previously referred to, do not apply if the child's parents or the young person has made suitable alternative arrangements. And subsection 6 confirms that specified in relation to an EHC plan means specified in the plan. You'll see the note there that says that the Act clearly sets out the must duties of the local authority and the CCG in relation to SEP. Now, looking at the ECH plan itself, for the purpose of our discussion this morning, the relevant sections would be section F and G. Section F provides for special educational provision required, that is SEP. Section G provides for any healthcare provision reasonably required. So in relation to those sections of the plan, section F is the responsibility of the local authority. Section G is the responsibility of the Healthcare Commissioner, which is the CCG. Where there is an EHCP, and either the local authority or the CCG fail to provide what is required of them, that can lead to proceedings in the High Court for the judicial review, with all the associated costs and resource consequences of that, which I'm sure you will all agree nobody wants, and they wouldn't want to go there. If we can then proceed to the next slide, please. You'll see the first bullet point. It's perhaps trite for me to say that CCGs are responsible for the commissioning and funding of health services for the general population within their geographical area. I'm sure most of you will appreciate that, but I set it out there as the starting point. These services can be commissioned from NHS providers or from private sector health providers. Types of health provision in these cases will usually, as I previously said, be occupational therapy, speech and language therapy, and physiotherapy, but would need to be required to facilitate education and training for the child or young person. What is considered to be special educational provision and what is to be considered as non-educational provision is a question of fact and degree in each case. In these types of cases, the question to be asked is whether or not the provision is directly related to the child or young person's learning difficulties. Now, there is a raft of case law that relates to that particular question, but because we have limited time in relation to this morning's webinar, we would be here for a substantial longer period of time if I was to take you through that raft of case law. But as general concepts, speech and language therapy would be argued that it is so fundamental to education that it should normally be treated as educational provision. Contrast that with for example, with the administration of medication by EpiPen generally for a child or young person, which is not required or not only required in an educational setting, could be argued as not. We will be having a short discussion from Jill about ICSs, but if we could just park that for the moment. The third bullet point is perhaps there to nail things home. The NHS and private health sector providers are responsible for the delivery of those health care services, and providers employ clinical professionals, EHCPs, to deliver those services. If we could go to the next slide, please. Yes, I set out here what the local authority's statutory obligations are. I'll run through those. They are that the EHCP is a statutory document provided by the local authority. The EHCP should set out the SEN of an individual and their SEP. Responsibility for the delivery of SEP is that of the local authority, and there is a mandatory duty upon them to do so under section 42, subsection 2 of the CFA 2014. The last bullet point states that the duty upon the local authority to make provision is non-deligible, i.e., the LA has to provide it, even if the CC indicates it will not do so. Let me put my teeth back in there. My apologies for that. In relation to the last bullet point, it would, I suggest, be an unusual situation for the NHS to refuse to provide healthcare services specified in Section G of the EHCP. And in order to illustrate that, under Section 42, subsection 3 of the Act, if the ECHP specifies healthcare provision, the responsible NHS commissioning body, the CCG, must arrange the specified healthcare provision. This is a mandatory duty, and likewise the individual who is the subject of the ECHP can judicially review the CCG if such provision is not made. Paragraph 9.141 of the SEND Code of Practice reads as follows. For healthcare provisions specified in the ECH Plan, the CCG, bracket, or where relevant NHS England, bracket, must ensure that it is made available to the child or young person. The joint arrangements underpinning the plan will include agreement between the partners and their respective responsibilities for funding the arrangements to ensure that services specified are commissioned. And when I refer to partners, I refer to local authorities and healthcare commissioners. CCGs will need, therefore, to satisfy themselves that the arrangements they have in place for participating in the development of EHC plans include a mechanism for agreeing the health provision, which would usually be delegated to the relevant health professionals commissioned by the CCG. CCGs may, however, wish to have more formal oversight arrangements for all EHCP plans to which they are a party. If we could then move to the next slide, please. Yes, you'll see there that I've set out the NHS statutory obligations, and the first bullet point confirms that Section 26 of the CFA provides for a duty upon LAs and local authorities and CCGs to make joint commissioning arrangements for education, health and care provision for children and young people with SEND. Second bullet point, the scope of joint commissioning arrangements are set out in the SEND Code of Practice, Chapter 3, paragraphs 3.9 to 3.35. As I've said previously, given the constraints of time, I can't really take you through the SEND Code of Practice, which is, as I've said, currently is around 300 pages long. The next bullet point says that CCG's main duty is set out in Section 3 of the Health Act 2006, which is to commission provision for healthcare in their local area. That then takes us on to the next slide, please. And over to Jill, who will talk a little bit about integrated care systems. Thank you, Jill.
Thanks, Kevin. I suppose the the point to flag in relation to ICSs is that we all know that they're coming. Various areas of the country have already started implementing the integration arrangements that will be needed once ICSs become fully operational, but we don't have any detail in terms of what's going to happen in respect of the statutory obligations that Kevin has just outlined, particularly in relation to CCGs, and what will happen to their duties once the CCGs are formally dissolved round about this time next year, assuming that we get there. So there is likely to be a degree of, I don't want to say confusion because that might not be entirely accurate, but there may well be a degree of blurring of lines, particularly in relation to the commissioner-provider split. And we're already seeing that with some of the steps in relation to integration that are being taken at the moment, where lead providers are taking on some of the commissioning responsibilities that CCGs previously had. Given the way that the legislation and the code of practice in relation to SEND is structured at the moment, I suppose I'm just wanting to flag up that over the next 12 months to 2 years, there may well be some knotty issues that come up in relation to whose responsibility is it to pick up and deal with particular things that may cause problems, both for CCGs and for local authorities in trying to finalise and progress what is in an EHCP. So you'll see that there are a few bullet points there in terms of who says what, who deals with what, and in practical terms, what happens if you end up on the receiving end of a direction from a tribunal. We see those from time to time. There is often not a full understanding of how the NHS works in terms of the commissioner-provider split, whose responsibility it is to provide what evidence, and who do you go to obtain the information that you need. I'm not suggesting that I have any answers today, and with 5 minutes left on the seminar, I don't have time to go through discussion points, but simply to flag up that this may well be an area that gets messy. And so just be aware of that so that when you're working through your policies and your integration processes, you have half an eye on this so that it doesn't sneak up and take you by surprise. We move on to the next slide now, please, Claire, and I'm going to hand back to Kevin.
Yes, thank you, Jill. Next slide headed the appeal process and tribunal. When I refer to tribunal, I'm obviously referring to the Special Educational Needs Tribunal. The first bullet point, it says, where can there be an appeal? And just quickly, the circumstances where an appeal might arise and lay with the tribunal relates to the local authority refusing to assess, the local authority refusing to issue a statement of need, parents disagreeing with the description of need and help offered. I'm, of course, talking about what is contained in the EHCP. Parents disagree with the identified school named. The local authority refuses to change the school name or to reassess. And the local authority refuses to maintain the statement or change the statement after assessment. In respect of the rest of the bullet points, I could talk about those for quite some time, but of course we're running short of time. But in relation to those bullet points, we can help and give assistance when a matter comes before the tribunal. And the areas where assistance might be needed relates to expert witnesses, AHCPs, report writing and evidence gathering, being a witness at a SEND tribunal hearing, giving evidence at a hearing, being a credible witness, witness compellability, professional obligations to cooperate, and where might mediation in SEND appeals be appropriate and useful. As I say, I could talk about those sub-bullet points for some time, but as time is limited, if we can move on to the next slide, Jill will talk a little bit about conflicts, and hopefully that will get us to the end of our 30 minutes. So over to you, Jill.
So this slide really sets out some of the more difficult aspects in relation to the involvement of professionals, and what tends to make the whole of the tribunal and EHCP process difficult is the position of the individual professionals involved in delivering the services and the support to the individual child. And that is partly because of the need to develop and maintain a therapeutic relationship in circumstances where professionals feel that they may well be pulled in two directions at the same time. And that is often the case where parents, in particular, sometimes the young person themselves, if they're slightly older, ask the professional for support and evidence in relation to their tribunal case, where there is a clear dispute and conflict between the family and the statutory commissioners. And that can make things very difficult in terms of maintaining the relationship and maintaining what is often perceived as a professionalism around the individual, because that therapist, that allied health professional can often be put on the spot regarding the specific needs and the particular level of provision that an individual child needs. And that is, I suppose, increased and amplified if the family wishes to call that individual as a witness at the tribunal, to provide evidence in terms of whether or not the current provision is thought to be sufficient or not. And that can be a really, really difficult position for those individual professionals to be involved in and for them to be put in, because there is a genuine internal conflict in a lot of cases between the position that the commissioner is espousing in relation to what is or is not necessary and appropriate to fulfill the EHCP and what the family would like to happen. And again, there aren't any easy answers, but just, I think, to flag that seems to be the basis of a lot of the queries that we pick up in terms of writing statements and preparing witnesses for tribunals, that those individuals feel that they're in a very difficult position in terms of progressing that positively for both of the bodies that they are involved with. That, I think, takes us to 1032 and the last slide. I know that there are a couple of questions that have gone into the Q&A. We won't have time to pick those up now and answer them, but we will respond to those questions in writing once the materials are circulated in relation to the seminar. So all that remains is for me to say thank you. Thank you for your time and for your attention. And if you wouldn't mind completing the feedback before you disengage from this completely, that would be very much appreciated. The final slide just has mine and Kevin's details on. If you need to follow anything up or you have anything else that you think we can assist with, then please do let us know. Thank you once again, and it's been lovely to see you.
Yes,
Bye.
thank you. Bye-bye.